Citizens, I regret to inform you, the court does not care how correct you feel. You may possess screenshots. You may possess outrage. You may even possess 27 pages of obviously. But the court asks only one question. Did you prove it properly? Truth without procedure is noise. And today, we are separating noise from law.
Section 1. Courts are referees, not investigators. A judge is not a detective. A judge does not go looking for missing evidence. A judge does not conduct independent research to help your case. A judge enforces rules. Think of a referee in a sport. The referee does not decide who deserves to win morally. The referee enforces the rule book. If a team commits a violation, the penalty applies, even if the team meant well. Courts operate the same way. Consistency produces fairness. If judges were allowed to chase whatever they personally believed was true, decisions would vary wildly. Procedure limits personal bias. Process restrains discretion. Structure protects legitimacy. That is why process matters. Section 2. Burden of proof. You must carry the weight. In court, nobody wins because they sound convincing. The person making the claim carries the burden of proof. If you accuse someone, you must prove it. In civil cases, the standard is typically preponderance of the evidence. That means more likely than not. In criminal cases, it is beyond a reasonable doubt. That is intentionally high. Notice what these standards measure. They do not measure emotional certainty. They measure evidentiary sufficiency. If you fail to meet your burden, the court does not declare you wrong. It declares that you failed to prove your claim under the required standard. You can be factually correct and still lose, because the court is not grading your moral confidence. It is grading your evidentiary presentation. Section 3. Rules of evidence. Not everything true is admissible. This is where frustration escalates. People say, "But I have screenshots." But everyone knows. "But I heard them admit it." The court asks a different question. Is it admissible? Evidence must be relevant, reliable, properly authenticated, non-hearsay, or within an exception, and introduced correctly. Hearsay is excluded in many circumstances because reliability cannot be tested through cross-examination. Screenshots require authentication. Statements require foundation. Documents require proper introduction. Why exclude potentially true information? Because reliability matters more than rumor. If courts allowed everything that might be true, trials would become contests of storytelling. Rules of evidence exist to prevent manipulation. They slow things down. They filter claims. They force structure. And sometimes that means something that feels obviously true never reaches the decision maker. That is not indifference to truth. That is protection against unreliability. Section 4. Deadlines. The clock is not emotional. Deadlines are rigid. Miss a filing deadline and your claim can be dismissed. Miss an appeal deadline and your judgment may become final. Statutes of limitations prevent claims after a certain time has passed. People react strongly, but the facts are still true. Yes, but the system requires finality. Without deadlines, disputes never end. Evidence becomes stale. Witness memory degrades. Litigation becomes permanent harassment. Procedure imposes time limits so society can move forward. Courts enforce calendars because stability requires closure. Truth does not pause the clock. Section 5. Preservation of issues. Silence has consequences. If you fail to object at the right time, you often lose the ability to raise that issue later. This is called preserving the issue. Appeals are not second trials. Appellate courts review the record. If something was not objected to, not argued, or not entered properly into the record, it may not exist for review. People say, "That was unfair." The appellate court asks, "Was it preserved?" Trial courts must be given the opportunity to correct errors in real time. If no one raises the issue, the system assumes acceptance. That may feel harsh, but it enforces discipline. Procedure rewards attentiveness. Silence is often treated as waiver. Section 6 Standards of Review. Appeals are limited. Another misunderstanding is that people think an appeal means everything starts over. Usually it doesn't. Appellate courts apply standards of review. Legal questions may receive fresh review. Discretionary decisions are reviewed for abuse of discretion. Factual findings may only be overturned if clearly erroneous. These standards are deferential. That means the appellate court is not asking, "What do we prefer?" It is asking, "Did the lower court operate within permissible bounds?" Even if appellate judges might personally disagree, they may still affirm because the question is procedural, not personal. Appeals are about rule compliance, not relitigation. Section 7. Why emotional litigants lose. This is uncomfortable but necessary. Emotion does not satisfy elements. Repetition does not increase weight. Volume does not strengthen evidence. Many people file long narratives filled with outrage, character attacks, and moral declarations. Courts decide whether legal elements are met, whether admissible evidence supports them, whether burdens are satisfied. They do not decide based on social media consensus, sympathy, personal frustration, repeated assertions. If your filing contains 20 pages of passion but no admissible proof, it fails. Process does not bend to intensity. It bends to structure. Section 8. Why process protects the unpopular. Here is the part most people ignore. Process protects you. It protects the accused. It protects the disliked. It protects the minority. It protects the socially unpopular litigant. Without burdens of proof, accusations could convict. Without evidentiary rules, rumors could dominate. Without deadlines, harassment could continue indefinitely. Without standards of review, appeals would become personal preference. Process limits power. It restrains judges. It restrains litigants. It restrains emotion. That restraint prevents abuse. When people say courts ignore truth, they often overlook that process is what keeps the system from becoming arbitrary. Section 9. Moral truth versus legal proof. There is a difference between what really happened, courts, and what can be proven under admissible standards within procedural limits. Answer the second question. They cannot answer the first unless it is properly presented. If something is not in the record, legally speaking, it does not exist. If evidence is excluded, it cannot be considered. If burdens are not met, claims fail. Legal systems prioritize verifiable proof over intuition. That may feel rigid, but rigidity prevents favoritism. Section 10. Why people assume corruption. When someone loses without understanding procedure, they often assume bias. They assume the judge ignored facts. They assume the system was rigged. Sometimes misconduct exists, but far more often, outcomes result from procedural failures, missing deadlines, inadmissible evidence, unpreserved issues, misunderstood standards. Ignorance of structure breeds conspiracy thinking. Understanding structure restores clarity. Conclusion. Stop asking if you're right. If you are involved in litigation, stop asking, "Am I right?" Start asking, "Can I prove it with admissible evidence? Have I met my burden? Have I complied with deadlines? Is it properly preserved? What standard of review applies?" Courts are not truth detectors. They are rule enforcers. You can be morally certain and legally unsuccessful at the same time. That is not injustice by default. It is the consequence of structured adjudication. Process is not the enemy of truth. It is the filter through which truth must pass. If you want to win in court, do not bring passion. Bring proof, properly, on time, within the rules. That is how the system works, whether we like it or not.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.